Hello everybody, it's Steve Katsikaris, Norland Cobequid Community Watchdog, Ryerson University student. I've just been reviewing the law recently over the last couple of days and finding some problems with Mr. Trudeau in the Vancouver courthouse obstructing justice and being part of miscarriage of justice. Just going to do a recap on what's happened here. There was a Chinese businesswoman that was arrested about a week ago. It's all because the Americans say that she's selling telecommunications to Iran, and that's a big no-no. It's not a criminal offense or a sovereign nation. But anyways, getting back to the injustice that's happened here in Canada. One, using an American to be judge for a bail. Remember, she had a crazy bail condition, and that's not a bail, okay? That's a house arrest that she's under right now. So she hasn't made bail. She is under house arrest, and she has to pay for her own surveillance, which is ridiculous, and I think it's like $15 million bail. All right? She is not a risk to society. She hasn't done anything wrong, and the Canadian government and also the Vancouver courts have basically admitted it. And how they admitted it is they say that the charges are sealed, and we can't tell you what she's done. They can't tell you, what the charges are and what exactly the facts and evidence of what this person's done. It's all speculation of lies, pretty much. So anyways, getting back to this, by reviewing Canadian court procedures and finding out that they haven't told anybody, and probably not her lawyer either, and I think there's something going on here, that when you deny someone bail, which she was, last week she got arrested at the airport. We talked about how the Canadian judge there, the American judge in Canada, wrote up an arrest warrant for her. No, that was another guy, sorry. Anyways, they went and picked her up at the airport and denied her bail. So she was arrested, they didn't say what the charges were, and she was thrown in jail and denied bail. And the excuse that the mainstream media said that she had too much money or something like that. That was just a ridiculous comment anyways. But that doesn't work. Now, the whole thing is that in order for justice to happen here, we have to follow the law and procedures. And if you take a look at here, it's called Form 19, all right? And if you look at the big line here, it says warrant reprimanding a prisoner. That means someone's been charged, and for some reason you don't want to let them out because they could be, a public risk or something like that. Like a good example would be an axe murderer. So if you caught a guy doing axe murder, you're going to let him out for bail for a year until he comes back for trial? No, of course not. You're gonna reprimand him. You're gonna remand him. Remand the prisoner. You're gonna make sure. So when they do this has to go before a judge. This goes into the disclosure file. Form 19 must be filled out when they denied that Chinese businesswoman. And getting back to her now, they did not do this because they're not saying what she's done. They haven't said the charge, but they have to fill this out. And I have a feeling they haven't given full disclosure, meaning they're not giving her any documentation of the accusations and the facts and evidence against her because there isn't any. And now they're not giving her a Form 19. And if you take a look here, what the Form 19 is here, I'm just going to read it out here really quickly. It says, I'm just going to start here. You are hereby commanded forthwith to arrest, if necessary, and convey to the prison at blank the persons named in the following schedule, each of whom has been remanded to the time mentioned in the schedule. So she has a court date, this Chinese businesswoman, in February. So if they're going to put her under house arrest, they got to have a Form 19 to say why she needs surveillance, why she's been charged, and what is the actual charge. They haven't done that. And then here we go. I was down at the bottom here. And I hereby command you, and this is a judge has to sign, by the way, the keeper of the said prison to receive each of the said persons into your custody, so that means keep him in jail, in the prison, and keep him or her safely until the day when his remand expires, and then to have him before me or any other justice at blank time. So that would be February for this woman, and they would tell you the courtroom and the time. All right? And then answer to the charge. She hasn't been charged officially with anything, and to be dealt with accordingly to law, like extradition. All right, so sorry, I just gotta get this screen back up and running. So you can see how the Canadian government is basically breaking its own laws. I'm just gonna blow this up again here, and then you can see a judge would have to sign that right at the bottom here of this Form 19. So this woman didn't get a Form 19, and they just went and threw her in jail. And she spent a whole week in jail, never been charged officially, and there's no Form 19, and now they're not coming out with the specifics. That means they haven't given her full disclosure. Now this is the other law that they're breaking, or sorry, Supreme Court ruling called Stitchcom 1991, and that's the year this happened. So we're going to go into Stitchcom 1991 and show where Mr. Trudeau and the Vancouver court are now breaking another thing in Canadian law, and they should respect the Supreme Court of Canada. You shouldn't have to go there to cry about Stitchcom. But you can see here, there it is there. This is a Supreme Court ruling of Canada. And it was political too, in some way, this case, and that's why it's in case law. Now, this judge needs to follow Supreme Court, all right? And same with the Crown. This is what they call being adversarial malice by the Crown doing this right now too. So the Crown's in a lot of hot water in Vancouver for doing this. So I'm just going to go over Stitchcom here and what it's about and just read it out to you. It's a landmark, Supreme Court of Canada. Okay, not the Supreme Court of the United States, the Supreme Court of Canada. Decision on the disclosure, meaning you got to come clean on the evidence in a trial, and is considered by most to be one of the most significant criminal law cases of the decade. The court found that the Crown had a duty, so don't be malice and adversarial, to provide the defense with all evidence, not some, not a bit, or none, like what's going on here with this Chinese businesswoman, that could possibly be relevant to the case. Well, yeah, sure. Regardless whether the Crown plans to call that evidence at trial or not, or whether it helps or hurts the Crown's case. There you go. By concealing this in Vancouver and not giving any evidence and not even telling the charge, this Crown is trying to plead a case in February of next year to extradite this poor woman under human rights violations. And Stitchcom says you can't cover things up even if it hurts your case, Mr. Crown. All right, so that's the Queen you're representing and the public interest. The case put to rest the long-standing issue whether the Crown could purposely deny the defense evidence that the Crown found would be harmful to their case. All right, so this is a Supreme Court of Canada ruling. The court in Toronto, the Supreme Court, it's not the Supreme Court, the Vancouver court doesn't understand human rights, fundamental rights, Supreme Court ruling. And you know what? They can't even come back and say, okay, Mr. Katsikaris, you're right about R versus Stitchcom, but let's talk about this, this, and this. They can't even do that. They can't even come back with case law the other way. So I'm just putting this up on the internet to prove that this woman hasn't been given full disclosure of her case, which is illegal, and it's the property of the accused, not the Crown and not the courts. All right? Under Stitchcom, anything that you prosecute anybody, Mr. Crown, in Vancouver, you have to give all full disclosure, even if it hurts your case. You must provide what they call natural justice to occur. And the accused has what they call the shadow of a doubt because they're innocent until proven guilty. This is Canadian law. And what's going on here with Justin Trudeau and that American judge in Vancouver playing these games and then putting this woman through what they call cruel and unusual punishment. And I'll tell you what my hypothesis here. The reason why they're not coming out and doing this is because they're using Stephen Harper's anti-terrorist laws. And now what that does is allows you to go grab somebody, detain them without charge, and suspend habeas corpus. Now, if Mr. Trudeau would come out and publicly say this is what we're doing to detain this woman, then he would look a little bit more legitimate. But that's what's happening here, is that the Canadian government is misusing anti-terrorist laws to arrest a Chinese businesswoman from a superpower because the Americans disagree on how the Chinese do trade with other countries around the world. And what the Chinese are doing is completely legal by international law. And what the Canadian government has done is violate human rights here in Canada, which now violates the human rights of the United Nations. So, Once again, this is not me. This is Canadian law. This happened back in 1991. We're in 2019 almost now, coming to the end of 2018. So this is old law. And to have that judge, who's a Yankee, yeah, I don't know what law he's using, but he sure is not as heck using Canadian law. And I say that he needs to be removed under the Public Services Act. Yeah, not following his oath, not following the Queen's law. I think that's really good grounds to dismiss him, especially if he causes cruel, unusual punishment and also suspends habeas corpus without any justified cause at all. So anyways, I'm Steve Katsikaris, your Norland Cobeconk watchdog, Ryerson University student, always looking out for the taxpayer and the environment. So take care, everybody, and so long. Take care.